This is 105.3, 95.3, WDXE.
Hey, that's us, WDXE, and we are live with Stan Pierchoski here, not only on WDXE, AM 1370, 105.3 FM, but around the world at WDXE.com, and also on Facebook and YouTube. If I've got all the buttons pushed, Stan, if I've got all the buttons pushed, we are live and ready to go with Stan Pierchoski. Estate Plan Stan, otherwise known, and we are all things estate planning.
Good morning, Jeff.
How are you, my friend?
I'm usually not too nervous on the radio until I heard you say "and around the world." So, okay, I didn't know that.
And we'll take your phone calls throughout the morning, too, by the way, 766-9393. If you've got questions for Stan, and he's always got something queued up and planned as far as topics regarding estate planning.
I do, and so far you've kept me going with some pretty challenging questions, and I encourage that. Keep them coming.
We will do it.
A lot of them stem from real estate. So, from your business, and there's something I want to actually bring up today about real estate that I think you'll find interesting and can probably even add to or chime into.
Sure.
We'll start with that because it's not really on the topic I was. We are kind of progressive here on the show on Bulletproof Estate Planning, where we kind of start from the beginning of like having nothing or having a will or moving into a trust and the different kinds of trust. We just sort of progress along in what I consider to be the natural progression of the thought process on this. And this has lots to do with what we do, but it's not on point from where the topic is for today. But it's something that comes up a lot. And when something comes up a lot, it's a good thing to bring up on these shows because apparently a lot of people have the same thought process. Mm-hmm. And now, I do a lot of deed work. Okay. Now, I don't do real estate work. So I want to make that clear that I'm not a real estate attorney. I get a lot of calls for that.
Yes.
But we do a lot of deed work because when you do a trust plan, you move your real estate into the trust. So we do deeds that transfer it into the trust. So we do a lot of that. But it often comes up that people... and it came up just recently where somebody was working with me and they said they were going to bring me copies of their deeds. And they said, oh, man, we brought the deed, but we tore the house inside out. I looked everywhere. I cannot find the deed for the house. And I said, what do you mean the deed for the house? They said, well, we bought this property, 20 years ago and went on it. And after we had it for 5 years, we built the house. They said, all I have is the deed for the property.
Yes.
And I've heard this before. I've heard it before. And it's a misconception. So, it can put your mind at ease for one thing. I said, well, stop looking because it's not there.
Yeah.
I don't need to know what's in your house to know that it's not there because when you have a deed, let's just talk about it a second, what a deed really is. Okay? Mm-hmm. You buy a deed. Let's just say there is no house on it. You buy land.
Yes.
In that deed is what we call a meets and bounds description. And that is the start here at this point on planet Earth. Go this direction for X number of feet or X number of poles and links in the old deeds or some measure of distance in some azimuthal direction, a 360-degree circle. Then stop and let the old deeds are kind of comical sometimes, at an 8-inch gum or an old hickory stump or a rock. Yeah. Something that they're considering a landmark at the time, and then turn and go this direction. The simplest would be like a square. But they're not. But they go around in a circle, and then they come back, and usually at the end of the meets and bounds description, it says, to end up at the point of beginning. And it'll usually say containing so many acres, more or less. Now,
right.
That meets and bounds description is what you own, or what that deed is claiming ownership of on planet Earth. It's where it is on the planet. Mm-hmm. And that meets and bounds description, in there resides all the ownership. So you own anything, that's your piece of land, and when you own real estate, you own anything that is permanently attached to it. Now, permanently attached to it is a house. Now, with the exception of like mobile homes, they are treated a little differently because they are considered vehicles.
Yes.
You can put a shed up that if it's considered something you can take down and take with you if you move. But a house, and somebody might say, well, you can hire a house mover to come move the house. That's true, but it's not considered mobile. It's considered permanently attached.
That's correct.
So if you buy a piece of property and pay $20,000 for it, it's just a field, a good building site, and you pay $20,000 for it, that you own that meets and bounds description. Now, a couple of years later, you say, I'm going to build a $200,000, $300,000 house here. So, you build the house. It doesn't have its own deed. It's part of the deed that you have. What you've done is you put something there that is permanently attached.
That's
And so
correct.
now that deed, if that deed ever transfers to somebody in the future, that house goes with it. And the way that's kept up with is if you take your tax card and go to the upper left-hand corner of it, it will have it'll say land value. That'll be like $20,000 or what you paid for it or what the land is worth. And it changes, with the census every year a little bit. But then it'll have improvement value. And the improvement value is what you've done to the land.
Correct.
So if you have $20,000 piece of land and you build a $300,000 house on it, the improvement value is going to be $300,000. And then it'll have total market value, which will be the sum of the two.
Sure.
And so your house is in there. There is no separate deed just for the house. Now I realize that if you have 100 acres and you build a house, real nice house up in the corner of it, that if you look at that and you try to section it off, you say, well, that corner up there has the most value, and that's true. But that house is on that. I mean, you can section that off and deed it as its own little parcel if you want to. But the point is there is no deed for actual structure that you build. It is the meets and bounds description, and whatever's attached to that is what the deed encompasses. And therein, in the deed lies the actual ownership of the property.
Correct.
So, so for this person and the other people that have brought this up, it's like, don't spend a lot of time looking for a deed to the house. There's not one. Find the deed to the property that it's on. You have this footprint. And, it goes, when you think about it, it goes all the way down into the ground, which gives you the mineral rights. The same footprint as meets and bound descriptions is down underground, belongs to you. And this column all the way up into space belongs to you, which are air rights.
Yes.
Okay. I mean, so you own that, and it's pretty cool. I mean, and you can, depending on what you have below ground or above you, those are things you can assign, lease. Those rights. You have a bundle of rights when you own a piece of property, and you can do whatever you want with them. So, anyway, I thought, have you ever run into that in your in real estate?
Well, yeah, and of course you mentioned mobile homes. We run into this, quite often. The mobile homes have titles like cars do. Now, once you can go through a process, if they are put on a permanent foundation, you can go through what's called a detitling process and make them a permanent part of the property.
And they're treated on deeds. Sometimes you'll see a deed that just references the mobile home.
Yes.
And I forget what that's called. Not the detitalization, but you have to, if it's there, you've got to acknowledge it in the deed. Normally in a deed, you don't have to acknowledge what's on it. I can say you got a big pile of junk.
Yeah.
You don't have to say in the deed, well, here's the deed and a pile of junk there. But when you have a mobile home, it's here's the deed and here's the mobile home that's on it too. And I think that's because a mobile home is kind of in this nebulous place in between mobile and permanent. Because if you buy a mobile home and put it somewhere, usually the intent is not to hook up to it and move it every once in a while, right? Yeah. It's kind of mobile to get there, and then that's it. So it's treated a little differently.
Yeah, we may be getting a question or
Sure.
something like that. Let's just check and see. And good morning. How are you?
I'm good. I wasn't able to get the Bible trivia or who won the drawing this morning.
Well, it was, let's see. It was Carson Lee Ward that won,
Okay.
and that's who won, okay?
Okay, well, what about the gift certificate or whatever?
They're going to get the Bible and the gift certificate. I give them both away at once.
Oh, well, thank you very much. And the weather, when it's bad, we would always be listening to you, Jeff, but when it's bad, we live down here in this holler, which is beautiful, but we can't get the news, so that's why I called.
Okay, thank you, hon. Bye-bye.
You have a good day.
You too.
Bye.
God bless. Thank you. Yeah, we got to catch up. We catch up on a little bit of the morning show, right?
Oh yeah. So that's just the thing I wasn't talking about deeds. It's kind of a misconception. So
yeah.
And the other thing about deeds that has come up, and again in Tennessee, there's really only 3 ways to own real property. And when I say real property, I'm talking about land. There's only 2 kinds of property in all the world. There's real, which is land and everything permanently attached, like we're talking about. And then there's personal, which is everything else.
Yes.
So someone says, well, what are my firearms? Well, they're everything. They're not. If it's not land, it's personal.
It's considered personal property.
How about my guns? Personal. What about my tractor? Personal.
There's a term, too, that you use, but we don't use it very often anymore. It's called chattels.
Yep. That is a old common law expression that means the exact same thing.
Yeah.
And so when you have the 2 different kinds of land. Now, when you own real property, there's only 3 real ways to own it in Tennessee. Now, unknown to some people, because a lot of times people come and they want to do a trust or something, or a will, and they'll say, I want to leave our home to my wife. If I'm the first to pass, I want it to go to my wife.
Yes.
Okay, well, When you own, there's three ways to own it. We'll talk about the first way, which is a married couple. If you're a married couple and both of you own the deed, so if it's Stan and Tammy Pierchoski on the deed, husband and wife, which you often when you look at deed, it'll say husband and wife.
Yes.
You own it by what is called tenants by the entirety with right of survivorship. Now, that's a default value. Whether you want it or not, that's how you own it. Well, let me put it this way. You can change that, but that's how you own it, whether the deed says it or not. So let's talk about what that means. Right of survivorship is unique because you're not really co-owners. I mean, you are, but if one of you passes away, now all ownership instantly at the moment of death vests with the survivor. Okay, so that's what right of survivorship is. So if you're a husband and wife, no need to say in an instrument like a will or a trust that if I'm the first to pass away, I want the house to go to my wife because it's going there anyway under right of survivorship.
Yes.
I mean, you can say it because a lot of times we want to conditionalize the way that happens, and the instrument can do that. But technically, it doesn't really even pass. It doesn't. I mean, I guess I could say it passes by right of survivorship, but you have two people that own it. They own everything, and when one person passes away, the survivor is now the only owner.
Yes.
That's why in a deed, let's say Stan and Tammy own a piece of property. And, I always pick on the husband, so I guess I'm going to pick on me. I'm the first death, and I die. Well, there's no need to re-up the deed and just put it in her name. Mm-hmm. So 20 years later, my wife decides to sell it. Well, when you sell a piece of property, the person that signs it is all the owners. And if you look at the deed, it says Stan and Tammy Pierchoski, right?
Yes.
So, do we have a defect because I'm now deceased? Well, no. We always put a little paragraph in there that says this is the same property acquired by Stan and Tammy Pierchoski back so-and-so when they got it, book and page number. And then there's a sentence that says Stan Pierchoski having passed away or having died on such and such a date.
Yes.
Leaving Tammy Pierchoski as a sole owner by operation of law and right of survivorship. Now, my wife can sign it and be the only signature for a valid conveyance, even though it originally had two owners. So,
yes.
So that's right of survivorship, and that's by default. You don't have to say it. Now, along those lines, a while back, they abolished right of, or what we call tenants in common with right of survivorship for anybody other than husband and wife. But the court shot that down as a restriction on alienation. And so now you can have, let's just say I decide I want to put my son on my property with me, with right of survivorship. Let's just say, okay, I want to put my oldest son on this deed with me as right of survivorship. You can do that. The difference is now the deed has to actually have the words. And it has to say joint tenant, here's the words I use, joint tenants with right of survivorship, not as tenants in common. And if it has that, it has to be a clear expression that you want the survivorship option. And if you, now, like a husband and wife, you don't even have to say it. It's there by default.
Yes.
But anything other than, if it's two non-spouses, it has to be expressed in the deed. So you can have that. You got to make it that way.
Tenancy's always been confusing to me. it can be very confusing. I don't know. You may not want to do this, but can you go through the different?
That's two of them so far.
That's two of them so far.
First one is right of, husband and wife, tenants by the entirety with right of survivorship.
Entirety. That's it.
And the second one is joint tenancy with right of survivorship. That's when two people are non-spouses and want right of survivorship.
Okay.
Now, the only caveat to the second one is one of those people can actually terminate the right of survivorship. When as husband and wife, it's you can't. But I won't go there. That gets kind of heavy. But so a lot of times, this came up recently when I had somebody who owned property with their brother, and they came to me and said, "My brother's real sick. He's going to pass away. He wants me to have the property. What'll happen when he passes away? Because he was terminal, right? So it's going to happen."
Yes.
Now that leads me to the third way to own property. You own property as joint tenants in Tennessee. Now, joint tenants is kind of what your people are used to. So let's take these two brothers. They own this piece of property. When you read the deed, it has language in it that says, John and Joe. It says John owns a 1/2 undivided interest.
Yes.
And Joe owns 1/2 undivided interest. Now, you can extrapolate that to as many owners as you want and how many fractional. It doesn't always have to be equal fractions. You know what I mean? You can have somebody has a 2/3 and somebody has a 1/3. You own this section. Now, when you own an undivided interest, there's no line drawn. So let's just keep it simple and say a 1/2 each, right?
Yes.
So there's no line drawn down the middle. What that means is you have an equal right of entry and an equal right of possession, which means John, the owner, owns everything. and he can do whatever he owns half of it, but he can do whatever he wants with the entire property.
Yes.
But if they ever sells, he only gets half the value because that's what he owns.
That's correct.
The other owner can do whatever he wants with the entire property. But if it sells, he only gets his half.
Right.
Now, when you run into problems is when what they want to do clashes or conflicts. Somebody wants to grow corn and farm, and the other one wants to build an amusement park or something. I mean, they're inconsistent goals, and they can't coincide.
Yes.
So that's when you run into some problems. Now, they own it. So when you own something like that, at your death, it doesn't just naturally go to the survivor. It is an inheritable asset.
Yes.
So let's take two non-family members. You and I own a piece of property together.
Yes.
Bought something, maybe a little investment value,
Yeah.
and I pass away. Well, you're going to end up owning it with my children because
That's
that's
correct.
mine, and I have a trust that says what I have goes to my kids. And so you're going to end up owning it possibly with 3 kids. And so you would still have your 1/2 interest. My death does not affect you in any way, shape, or form. But now my children would have 1/3 of my half. And
That's correct.
If you're good at fractions, like I like to think I am from my engineering days, they each own a 1/6 of
Yes.
the entirety.
Yes.
They have 1/3 of my half, but 1/3 times a half is.
It's interesting that we're talking about this because I'm in the middle of a closing right now where the property is in eighths.
Yep.
There are heirs to the property, and they're actually in eighths. There's, this one may own 3/8 of a property, and the other one owns 3/8 of a property, and then somebody else owns, only 1/8.
That's right. It gets pretty diluted pretty fast sometimes.
Yes.
And you get into, and that's exactly what they own. Now, so that's the difference there is it doesn't go anywhere at death. It's an asset. It's like a bank account in the bank. You pass away, your estate has this asset in it. And the asset is this 1/2 undivided ownership.
Yep.
And so now that's the third way that you can own property. So those are the only three possibilities here in the state of Tennessee.
Interesting. But people get confused about that, and that they think about being able to say, let's say you and I bought a piece of property. It was 10 acres, and we are tenants in the entirety.
No, if you
tenants
and I
in
buy it as
common.
and we're non-spouses, it can be joint tenants with right of survivorship or just joint tenants.
Okay, but we own the whole. In other words, you don't go out there and say this 5 acres is mine,
That's
that
right.
5 acres is yours. We own the whole 10 acres together.
You own half. We just don't know what the half is.
Right.
Yeah, it could be however you divide
Right.
it.
So you
That's
can't say that's 5 acres I want and that's the 5 acres I want. No, you own the whole thing together, half each.
And remind me when I finish this example with the brothers that to come back and talk about when you have to deal with partitioning that kind of ownership.
Yeah.
So anyway, going back to the brothers, so they, he asked me about what would happen when the terminal brother passed away. And
Yeah.
I said, well, let me see the deed. I got to see what it says.
Right.
And the deed said, John, exactly what I said. John has a 1/2 undivided interest. Joe has a 1/2 undivided interest. And I said, if something happens to him, I said, does he have any children? Yes. Well, that's going to pass to them probably, unless he has a will that says it goes somewhere else. He said, well, he wants me to have it. I said, well, you can do 2 things. One, he can draft a will or a trust that says his half goes to you. Or you can do something a little simpler and just redeed it from the 2 of you as 1/2 undivided as joint tenants to the 2 of you as with right of survivorship. And so that's what we did. So I drafted a deed and used those very words where I said John and Joe as joint tenants with right of survivorship and not tenants in common. And so now at his death, which is he's terminal, so it's a sure thing.
Yes.
When he passes away, it instantly vests with the survivor, and so that sort of fixed that. So going back to the way we can own property the third way, this undivided interest, this can cause problems, and I think people approach this sometimes a little bit too lackadaisical, or maybe that ought to be the word for the day. One of these,
Word of the day there.
Kind of without much thought or without giving it much forethought. So let's take an example of what I see a lot of. We'll use me. I got 3 kids. And let's just say I leave, I got some acreage up in the northwest corner of Giles County. And let's just say I leave in my trust or my will, I leave everything I own, including my real estate, to my 3 children in equal thirds. Okay?
Yes.
So I got about 150 acres, and it's like, okay, where's the line drawn? Well, like I said, there is no line drawn.
Right.
Now, they all own it. Now, suppose 2 of my kids, or one of my, let's just say, keep it simple. Suppose one of my kids moved away, lives in Florida, has a family of their own, and they come back and visit, but they firmly established in Florida and stuff like that. And they, after I pass away and the property is distributed, now there's going to be a deed that says from the estate of Stan Pierchoski to child one third undivided interest, child two, child three, each a one third undivided interest. Mm-hmm. And the one that lives somewhere else or far away says, you know what, I really don't want to be involved in a piece of property in Tennessee. I don't want to have to deal with it, rent it and deal with renter or pay the taxes on it. I just want my value out of it. So she says to the other two owners, buy me out. Okay.
Yes.
Now that can happen.
It does happen.
It does happen. So but the other two have to buy them out. And they got to buy them out for fair market value and agree on a price. There's no. Now, and so if they buy them out, now what do we have? We got the other two owners have a 1/2 interest, right? Correct. So it's pretty simple. But that's not what usually happens. What usually happens is the other two either won't buy them out or can't buy them out. I mean, if you're talking about a valuable piece of property,
yes.
The other two might say, I don't have enough lead in my pants to do it. You know, I can't.
Right.
I want it, but I don't have enough money. I mean, you can work out an agreement or something, but but a lot of times they just won't, and they say, no, I'm just not going to buy you out. Now, you can't have this what we used to call Mexican standoff. You can't just come to a grinding halt and have this person now be stuck with this piece of property that they don't want anything to do with anymore.
Right.
And so they can force a partition sale, which means they can go to the court, and the court we have a partition statute, and the court will first, give deference to see if they can divide it, mm-hmm. and if they can draw lines and be equal with it, which is very hard to do, especially when you draw these lines and it's like, okay, there's no road frontage on this one, or it's very, very
Run
difficult.
into that before, and it's almost impossible to get everybody happy.
The statute says first do that if you can, because they just recently modified that statute. And basically, it says partition it if you can. But it's got to be a third. It's got to be equal value. Right. And okay, a piece of property's got a nice field, and then it's got a hill full of trees. It's like really steep and really just holds the world up. So there's all kind of difficulties with that.
Very.
But if you can't, then the court will force its sale and divide the money. Now they know that's a third equal, right? It's easy when you divide money. That's a walk in the park.
Right.
Now that person that forced partition sale has their value. The other two have their 1/3, but they don't have the land, which is kind of what they wanted. Right. So we end up, people say that's an inequitable result, and it kind of is. It's not inequitable. It's just not what the people wanted. Right. Now, let's go through that, because why can somebody force a partition sale? Yeah. If you have, let's take the one lives in Florida that says, I have a third interest in this piece of property in Tennessee, and the court will say that your 1/3 undivided interest is an unmarketable title. Now, what do they mean by that? Okay, suppose my child that's in Florida says, I want to sell it. Yes. I put it up for sale. I go to a real estate agent, I'll list it. Who is going to buy a piece of property with two people they don't know, the other two children? They don't know what they're going to use it for, because remember, they all can use the whole property for whatever they want. Mm-hmm. They don't know what they're going to use it for. They don't know what they're going to do with it, what kind of people they are. Nobody is going to buy that. The court recognizes that. You can't sell that. The only person that would buy it are the other owners. Or maybe somebody else in the family, maybe the person trying to sell it has an adult child that wants to. I mean, it's very limited.
I've actually done this.
Yeah. And so because it's an unmarketable title, now you can do a partition sale and it get to the court. The best, and that is a very, very expensive process, and it's a very lengthy process. Now, it's not, I mean, the best thing is to work together and try to figure something out. So I've seen people say, buy me out, but I'm not going to be real cumbersome about it. If you have to borrow money from the bank, and if you can buy it and you can pay me over 5 years or something like that, do so. It's always better to work something out. But so we can reach a conclusion. So when you leave property with this, most people have like one piece of property, but more than one child, and this comes up, and it comes up often. Once I said something as ridiculous as this. I said, the ideal situation is you have 3 children, you own 3 pieces of property, all of identical value, and at your death you say, "Here's this one goes to you, this one goes to you, this one goes to you," and that's but never happened. But you were saying this. You were saying maybe you want to share, a circumstance.
Well, I had a circumstance where that was taking place. The gentleman was 1/3 or 1/4 owner in a piece of property. He wanted to sell his undivided interest. He wanted to sell his interest, and it ended up it's just a crazy story, but he sold it very much less than what it was worth, and was able to find a buyer who did exactly what you think they wouldn't do, but did.
No, I didn't say you can find a buyer.
It'd be very impossible.
It is just really unreasonable.
Well, the only way it would happen is something like that, where he basically just did not want the property and basically almost gave it away.
Oh, that you can do.
So it's that was a very unusual circumstance.
But one thing it also does, it really creates discord among the family more often than not. I mean, it usually creates people hard feelings. People they just. I mean, it's just it can get ugly, is what it can get.
Yeah.
And so, let's see. There was something I was going to say about that. And when you're talking about the people that will want to sell. So let's say you have 3 kids and they all say, hey, this is the house I grew up in. I don't want to sell it. I'm going to keep my third. A lot of times it's like that.
Yeah.
When you run into problems is this. Okay, so I have 3 kids. And they all say, we grew up there. We want to keep it. Maybe we'll rent it out or something. But we don't want to part with ownership.
Yeah.
All right, one of my kids dies and they have 3 kids. Okay, so they each inherit a third of that third, which is 1/9. So getting to where you were talking about. Now, what are the chances those kids want to keep it? They didn't grow up there, Or if one of the, sometimes they call it heir property. Now, one of those die with a couple of kids. Let's say 3 kids. Let's keep it 3s, okay? Now those kids own a third of a 1/9, which is 1/27, right? Yeah. And now that these people are getting so distant, those are all going to say, hey, I just want to be bought out. Buy my interest and give me the money.
Yeah.
It's more and more likely as you dilute it like that because there's less and less interest to the original intent when it was left to the children. So, now when we do a trust, it's hard to do this in a will, but when we do trust, many, many times, I will put language in there that if we leave the property to these 3 kids, a requirement of your inheritance is if you elect to sell, you have to give the other owners the first opportunity to buy. I've heard that's referred to as the right of first purchase or the right of first refusal. It's kind of the same thing.
Yes.
But before you go to the open market or go to court for partition sale, you have to afford them the opportunity. It has to be a reasonable opportunity to buy. If somebody says, "Yeah, I want to buy it, but I won't be able to buy it for 20 years," that's not reasonable, right? So,
yeah, exactly.
And it gets cumbersome because what if you got somebody there it's a farm, because in this neck of the woods it's a big deal, the family farm, and it's income producing, and you got one of the children that's been working it with dad. The other 2 kind of went their separate way, but he's been there working it with dad for years and years, and now dad passes away. He wants to continue working it. The other 2 want to sell it, and it could jeopardize his livelihood if he doesn't have the wherewithal, or if he didn't have enough other assets that he inherited to buy that property out. Mm-hmm. And there's no secret that I have a very strong deity, and I'm a staunch studier of the Word. And in your scriptures, it talks about something called the patriarchal family. And the patriarchal family is you leave all the land to the oldest male child or the firstborn male child.
Right.
That is the birthright. Now, is that unequal? Well, you could look at it that way, but with that birthright, that child has the responsibility to take care of everybody else because he has the means to do it. He has the land. And it keeps, I think it's a grand idea because it keeps the land in the family, and once you get to this fractional ownership, the land is doomed. That's all I can say as far as staying in the family. It is just doomed. But here it goes to the birthright goes to the oldest son. He keeps it, and if it continues on from generation after generation, now you start. These farms and almost these family business get tremendous wealth and tremendous value, and they grow. I mean, I think that's why the government kind of puts the kibosh on that. They're too much power grows when that continues like that. So, I mean, I'm not going to go there. We're not going to that soapbox, but it's that concept cures that problem. But it's if somebody has a piece of property and that's the lion's share of their estate, and they got multiple children. Well, they feel it's too inequitable to leave it to the one child and much less to the others. And I get that. I get it. Again, ideally, if you're going to have one piece of land, ideally you have enough money in the bank to say, okay, I'm going to leave the land to child A, but I've got enough money to give B and C the same amount of value in cash. Now that would be ideal if you got the assets to work with.
Yeah.
Not always, but sometimes. So
Very good.
it's land ownership is unique. It's unique. We deal with it a lot, like I said, because we transfer a lot of property into trusts, and we deal with some of those old deeds. Before I get off this subject, one of my pet peeves on deeds is I do them. I don't do them in duplicate. I don't punch holes in them and put them in the binder like everything else, because I think they're formal documents.
Yes.
And whenever people sign a deed, I say, okay, here's the way your name is. So, like for me, if it's my middle name is Kurt. So if it's Stanley Kurt Pierchoski, I say, sign it just like I have it under the line, because that's how it was on the deed before. And I'm a stickler for that.
Yeah.
When you're signing my trust documents, like the trust or the certificate of trust, and I say the name is Stanley Kurt Pierchoski underneath it, but sign it however you want. I just put your name under that way for the legal identifier. Right, you sign it however you want. You put an X if you want. You're identified. It's witnessed. It's notarized. We know who's signing it. It doesn't have to be legible. It can be a doctor's signature. It doesn't matter. But on a deed, I say you can sign it. It doesn't have to be legible. Just sign it. Even if I'm used to just saying Stan Pierchoski instead of Stanley Kurt. And so if I just I want to sign it just like it is, because that's the way it was before.
Right.
One thing that drives me crazy, a pet peeve of mine, is when you get a deed. And two things. One, you get somebody that ends up with so many different names. Typically women, don't call in and yell at me, but they get married names. They keep some of the married names. They keep the maiden name, then they get rid of some married names.
Right.
So you might have Jane Doe. It's Owen Point. Then you have Jane parenthesis Doe Smith because she gets married. Then she gets married again. I get Jane Doe Smith Jones.
Yes.
And then sometimes they'll lose the Smith, or sometimes they'll just use an initial, and sometimes it's a different initial. And so when that happens, what I like to do is when I finally find all of them, I'll put a paragraph in there that says Jane Doe Smith, Jane D. Smith, and Jane D. Jones Smith being one and the same person.
Yes.
Language like that. But it drives me crazy when people use nicknames, like Bubba. Bubba Smith. He signs a deed, Bubba Smith. It's like, that just... because you got to think of it this way. 30 years from now, if some title insurance company is doing a 30-year title search,
yes,
I mean, you want to know what happened, right? You want to be clear. A deed should tell a story. It really should. So that's just one of my pet peeves when I find these nicknames and stuff, or it's fixable. It just bugs me.
The overall thing that I get from talking with you and others like you that I do in the business that I do is how important it is to get the documents and the language and the signatures correct, and then of course get them court recorded, because down the road in history, or in the future, someone's going to need to deal with it.
Yep. There's a procedure. I got to tell this story. I didn't mean to. I got to tell this story. We'll keep it generic. I was doing a trust administration, and it was. Anyway, the trust administration means after the trustee passes away, we're distributing the property.
Yes. And
there was a divorce. The people that were receiving the property were in the middle of a divorce, so I made it kind of extra complicated. And so we were trying to do both of them were the same, because theoretically, if you go step by step, the trust would distribute the property to the two people, and then the two people would distribute property as a result of the divorce, right? And so we kind of, instead of going through the different steps, we were going to come up with the same result, just kind of jump to the same result. You know what I mean? So, And so we're going through it, and there's a lot of property involved. And I remember sitting down with the people that work for me, and we were going through it, and we couldn't account for a piece or two. We just couldn't, or a little bit of acreage. We just couldn't find it. We searched. I even have some people that are experts that do a little freelance work. And when I have trouble with an ownership or a chain of title, I bring them in, and they're very, very good. And they couldn't find it. And the people on the other side of the divorce were looking at it. And we compared notes, and they were very experienced in deed work and chain of title. We couldn't find it. So I'm talking to my client. He was elderly, and I'll never forget. I said, we're having so much trouble, and I'm pointing out it's just it's like an acre and a half or something.
Yeah.
He goes, "Oh, is that acre and a half over there by the bend in the creek?" Or it's like I'm thinking, all right, he knows what I'm talking about.
Yeah.
We're gonna get the answer, and we did. And he said, "Oh yeah, I remember that. My daddy had so and so was his neighbor at the time, and he traded that to him for a bull." And I said, "Well, was there any document?" He said, No. Back in those days, you just here's your bull, here's your land.
Yeah.
There it was, and there it wasn't.
Yeah.
So, do we have a defective title?
Yeah.
Yeah, technically.
Yeah.
So, because there's a procedure when land conveys, you have to be able to prove ownership, or you don't own it. We have these adverse possession statutes that deal just with that.
Yeah.
So anyway, it was able to get cleaned up. But I mean, boy, it was almost good that we found it. But it was like I could have reached across the table and wrung his neck, or if his dad who did that, well, But anyway,
Want to try a phone call again?
Sure.
Let's see if we got one.
I wasn't paying attention.
Good morning. You're on WDXE with us.
What happens when a man, a husband dies? He owns a little property and a house, and he's got a wife, but he dies. Does she automatically get what he had, the house and the property, or what?
Okay, that's a good question. Let me ask a question. Are you referring to if he owns this house, you mean he owns it in his name only? Or he owns it with his wife?
I don't think her name was on the deed or the property.
Okay, let's just assume it's owned by him only. Because we talked about if it's owned by husband and wife, it definitely goes to the wife.
Yes.
So let's talk about the situation where John, the husband, owns it in John's name only. Well, that's an asset he has, and if he has a will and says everything goes to my spouse, then that's where it would go. Or if he has an instrument saying where his property goes, that's, remember we talked about probate before and avoiding probate? Well, if you're the husband and you're the first to die and you own something in your own name, that has to go through probate.
Yes.
Now, so if you have a will and it says where your stuff goes, well, then that's where it goes, whether it's the wife or not.
Yes.
But if you don't have a will, then the laws of intestate succession will pick up, and that looks to, do you have a surviving spouse, and it looks to your natural descendants. So,
yes.
And it says a surviving spouse gets 1/3 or up to a child's share. Now, the only time it gets up to a child's share is if you have one child. Then they get a half each. If you have 2 children, then everybody gets 1/3. If you have 5 children, the wife gets 1/3, and the others get 1/5 of 2/3.
Okay.
So what's 1/5 of 2/3? If you do fractions in your head, it would be 2/6 or a third each. Okay. I'm sorry, 1/5 of 2/3. So it would be 2.
We're going to hurt our brain.
2/15. 2/15. Okay. So each. So hopefully that answers the question, because those are the only possibilities it can be. He owns it in his own name. He passes away without a will, and it's going to go to the surviving spouse and any descendants, natural descendants, not stepchildren, bloodline children.
Okay.
If he has a will, it's going to go to where he says in the will, or if he has a trust. Well, if he has a trust and it's a joint trust, it would still be the wife's. And the other option is if he owns it, with the wife. We talked about that as right of survivorship. Yeah. So hopefully it may not be the answer you want to hear.
And if there are no children?
If there's no children, it's the surviving spouse gets 100%.
Yes.
Yeah. So it may be not the answer you want to hear, but it's an answer. Now, brings up an interesting question. I think I talked about this when we talked about probate.
Yes.
Suppose you have a will and it leaves the wife out of it. You can disinherit children. You can't disinherit a spouse because there's a thing called elective share that can be that you can exercise. But that may be a topic for another time. So, listen. As long as we're talking about real estate, I didn't quite get to the topic, but what I was going to talk about, and this is kind of along the lines of real estate, and that is we were talking about crisis planning, meaning somebody's in a nursing home.
Yes.
And we're saying, okay, what do we do with our assets? Well, we talked about how you can convert them by a direct consumer transaction, fair market exchange. You can take a countable asset like money in the bank and buy personal property, which is a non-countable asset, right?
Yes.
We talked about being able to do that. I think I used a car for an example. So now the question is, all right, we talked about if you give something away, that makes it non-countable. But now you trigger this, we gave it away in the last 5-year business, what they call the 5-year look-back rule. It can trigger a penalty period.
Right. So
the question would be, can we ever give away property and not suffer the penalty? And the answer is yes. There are some exceptions to the rule. Now, these are exceptions written into the code, the 10-Care Act, which mimics a lot of the Social Security rules. And there's several exceptions. I'll probably have time to talk about one. And the one I want to talk about, one of the exceptions to deed a piece of real estate, and when you talk about giving it away, that's any asset, but this exception deals only with real estate. And you can deed this property away without incurring a penalty. And it's called the family caregiver exception. And the way it works is this. There's 4 things you got to satisfy. If you satisfy these 4 things, you can deed the property to this person penalty-free. the day before you go into the nursing home or the day before you file your application or even after, for that matter. But you can just give it to them and no, you don't get anything for it. I don't care what the value of it is. You deed it to them and there's no penalty. Where anything else you give away, we're going to suffer a penalty, right?
Okay. And
that exception, we call it the family caregiver exception. It works like this. If you can prove that a child, okay, that's number one, it has to be a child. And now, this exception is a great exception, but a lot of times it comes up and it just won't fit, because my light bulb goes off. I say, oh, great. And it turns out it's a grandchild or it's an in-law. So it has to be a child. So if you got 3 children, you got 3 choices. It can't be their wives. It can't be children of theirs. It has to be a child. If you have a child who moves in and lives with you in your house, that's another one sometimes. Yeah, I've been taking care of grandma. I've been taking care of mom for years, but she's living with me. Okay, you have to move in and live in their house. Okay, so you have
very
to
specific.
Number 1 is a child. Number 2 is you have to move in and live in their house. Number 3 is you have to be taking care of them for a period of 2 years prior to them going into a nursing home. Okay, so that 2 years is a moving target. So whenever they go to nursing home, you got to go back 2 years and say you've been taking care of them. Mm-hmm. And the third one, that's the third one. And the fourth requirement, which is probably the easiest one to get, is you have to get a doctor's opinion that says something like the care you've been giving rises to the level of enough that has kept that person out of the nursing home. Okay. Yes. Now, if you satisfy all 4 of those, it's kind of like a reward because you've kept this person from being a ward of the state and going into the public's benefits and stuff like that. If you can satisfy those 4 things, the applicant, the person being taken care of, who owns the home, can deed the entire property to that caregiver child penalty free, no penalty whatsoever. Got to satisfy those, and those are the things I see that throw a monkey wrench in that. I mean, I've had ones where it was a perfect fit, but it was a grandchild.
Oh wow!
No dice. Perfect fit, but mom moved in with them.
Yes.
Perfect fit, but it's only been a year and a half. Now, if it's only been a year and a half, then we look at it and say, can we continue doing it for another 6 months?
Yes.
Is that possible?
Yeah.
Or is it are we at the point where we just got to be in the home? I mean, if it fits, it's great, but they're very, they will scrutinize that. When you turn that in, they want proof, and they will scrutinize it. Now, I've had people say, well, I've been living here, and everything's satisfied, but they have another piece of property of their own. And, they get mail at the other property and stuff. Now we got to prove that they actually live there, because you have to live there. And we've done that. We've been successful. We get affidavits from neighbors that say, yeah, they're here all the time. They're here. Just some other outside proof, and that usually carries the day when we can do that. You don't have to. It doesn't have to be that strict that you got to show that you get your mail there and your car is registered to that address. You just literally have to be living there, taking care of them. Like I said, the doctor's opinion is usually the easiest thing to get.
Yeah.
The other ones are where we run into the problem. And so the other exception, which I can probably work in here, is kind of similar, has to deal with the real estate again. The only thing, if you satisfy this exception, the only thing you get to do is pass the real estate to the other person and a penalty free. And that is the sibling exception. This is a little more rare, but I've had it happen twice.
Really?
And if you live in a home with a sibling and you both have an ownership interest, so it doesn't have to be a half, it's an ownership interest.
Okay.
Right? Typically it is. You got, people get in their advanced years and, they got a brother or sister and they live in the same house together and they both have ownership interest in it.
Yeah.
You just have to have that arrangement for 1 year before going in the nursing home. You don't have to be a caregiver. So let's not confuse the two. You don't have to be a person taking care of that person. You just have to share ownership for a year before.
Okay.
If that's satisfied, you can deed your interest in it, like we talked about earlier.
Yes.
Whatever you own, whatever that is, it's half, 9/10, or whatever. You can deed that to your sibling, which is a gift.
Yes.
And not be punished for giving a gift. There's no penalty free. You can deed it penalty free.
Yeah.
And so that's, we've got the caregiver exception and family caregiver exception and the sibling exception. Now that's rare. Now the last point I want to make about these 2 exceptions. Mm-hmm. A lot of times people come and say, well, I remember I mentioned this crisis. These are things that we can do in crisis and stuff, but you can't. The crisis tools don't apply until you're in care. So somebody comes to me and says, well, Dad's sick, and there's no way he's going to make 5 years for the trust we talk about. But he's not going in the nursing home tomorrow either. I figure he'll probably be there in 6 months to a year or something like that. But we don't know. We're crystal balling it, right?
Right.
So the question is, okay, we're in this nebulous period. Is there anything we can do that we can set up circumstances that would benefit us for but we don't know when he's going in, but it is inevitable. We know it's going to happen. We just having a hard time with it.
Sure.
So what can we do to set things up to mitigate the impact of that? Well, these two exceptions are possibilities. So how about, okay, this is our house, and I want to inherit this house because I grew up in it. It's a valuable house. We don't want it to just get consumed in the cost of care, right? All right, I'm a child. How about I move in with Mom and take care of her? And I'll do it for 2 years. Once I get there, now they can deed it to me. Now, you don't have to be in the nursing home to have that deeded to you.
Okay.
So you can set the circumstances up. If you're a sibling, I've done this with siblings. We had the perfect setup with siblings.
Mm-hmm.
Neither of them was in a nursing home. We're headed that way soon, but they were elderly. And the only thing they didn't satisfy was the sister didn't own any of it. So the brother owned it all, but the sister didn't own any of it. But she'd been living there for a long time.
Oh, yeah.
So I said, okay, you need an ownership interest. You can do it one of two ways. You can buy an ownership interest. If you do, then we've satisfied it immediately. Or you can give it to her, and now we got to wait 5 years. But after 5 years, her ownership interest doesn't trigger the penalty period. Okay, so there's a couple ways to do that.
Wow.
And so we set that up, and now those folks, these are people that maybe we don't ever go in the nursing home, but if we do, and certainly it has to be circumstances that your family dynamics will support.
Right.
Some people say, hey, I live down in Florida. I can't move in with Mom and Dad up in Tennessee and take care of them.
Yeah.
Well, then this exception is just not going to work.
Right.
But, if you're a lot of people, they're taking care of Mom and Dad anyway.
Sure.
And if that's the case, maybe we can modify how we're doing that. So when the time comes, we can save the lion's share of the estate, which is the house or the family farm, and deed it. What you deed, it has to be the personal residence. Let me clarify that. So you deed the personal residence to them penalty-free. That's a tremendous advantage.
Yeah.
Now, in Tennessee, what is the personal residence? I got just enough time to cover this because you'll love this. This is beauty. It's like where I live, right? Yeah, that's right. Now, personal residence is defined, and this goes back to what we started the hour with, a deed that describes your land.
Yes.
So if your personal residence is a 5-acre lot and your house is on it, that's your personal residence.
Correct.
But the statute says your personal residence is defined as your personal residence and any property that is contiguous.
Okay.
And further goes on to say that there's no third-party landowner in between. Because we deal with real estate, we talk about the personal residence, and then we talk about other real property.
Right.
The personal residence enjoys a lot of special things in 10-care planning. Other property is just an asset.
Yes.
Think about it. We have these family farms. We had a farm one time, and I'll bet there was over 1,000 acres in it, if I remember right. And what happened was, Dad years ago bought 30 acres. And as years go by, the guy next door sold and he bought him out. And then he left the property to his son, which was my client. Over the years, over 40 years, he bought some property here, he bought some property there. They ended up with 1,000 acres. When you put it on the map, every piece of property they have touched another piece of property that touched
they bought
the
what joined
personal
them.
residence.
Yeah.
Okay? So by definition, by statute under the 10-care Act, the personal residence is all property that is contiguous and there's not a third-party property owner in between. So let's say they had 10 acres, but it was down the street, and Bob Jones lived between them, right? That one's not part of the personal residence.
Okay.
We had 1,000 acres personal residence. And now, the situation was they had a caregiver situation going. They were only about a year into it. Mm-hmm. And so we sat down and said, look, whatever you do, stay taking care of this person for another year. Tough it out. 1,000 acres, a couple $1 million worth of value.
Yes.
Penalty free.
Yes.
Because of that. Now, that's a beautiful
result. That's a big deal.
That's a beautiful result. Now, again, if the shoe fits, we do it. Some people, I can't do it because I live somewhere else, or I got a job and I can't take off and take care of Mom and Dad. I get it.
Right.
It has to work. But when we think about it in advance, maybe we can make it work. Maybe we can adjust our circumstances to make it work. So anyway, and again, you know, if you're thinking this, you can't hire somebody to stand in your proxy and take care of them and say, "Well, it's me because I hired them." That's good thinking, but that's not. It won't work. that tells me you're thinking if you're coming up with that.
Well, this has been very interesting stuff because it's stuff that I deal with too sometimes, but not as quite in the, I guess, in depth in the legal end as you do. But still, I see it. I see a lot of it. Let's take the last couple of minutes we've got here and remind them of where you are and how to contact you and how to listen to you elsewhere, all those things that we talk about just a little bit.
Well, we just had a seminar last Saturday for one thing.
How'd that go?
That was over in Pulaski. Oh, it went great. We had a lot of good people there. Pretty good crowd. Next one coming up is this month, August the 19th, which is a Saturday again, although that one's going to be up in Franklin. There's a place up there. It's called Suite 501. It's on Mary Lindsay Polk Drive. The actual number address escapes me, but I think if you type in Suite 501, you'll get it. We're doing that at 10 o'clock again up there. So if you want to come to that, that's a couple of weeks out.
Yeah.
And so that's the next one. But you know, you can call me at my office, which is Pierchoski Estate Law, Pierchoski Elder Law. The number there is 931-363-7222. You can go to my website, which is Estate Plan Stan. Now that's not State Plan Stan or Real Estate Plan Stan. That's Estate, ESTATE, planstan.com. And if you go to my website, you can RSVP to my event. You can look at the calendar and see when the next one is. You can get my phone number, my email. You can ask a question that way or contact me that way. And there's a lot of good reading and some YouTube stuff on my website that you can take advantage of. So, you know, we're there we're located. You got to be located somewhere. So we're on the square in Pulaski, right beside the Star Theater. You can't miss it. Which is where we had the seminar last week. Now this seminar I have in Franklin, that's a great venue. It's really cool because I don't have to tote my big TV up there. They got a lot of electronics. They got a huge TV. It's one of the biggest ones I've ever seen that I can just plug into.
Sure.
But it's limited in size. You know, when we use the Country Cafe back here at WLX, and we use the Star Theater, those are big venues, a lot of roll-out tables and chairs. We can sit a lot of people. Yep. This place has a maximum of about 50, which is around where our attendance gets, you know, somewhere around 40 or 50. So might be a little limited on that. So if you want to come to that, give us a holler and get on the list. Yeah. We usually keep a waiting list. Last time we were up there, we were only up in Franklin once before, but we had a waiting list, but we had some people cancel out. We were able to get everybody in. So, give us a call, 931-363-7222. Set up a 15-minute phone call with Estate Plan Stan, and I'll dedicate that time to your question.
That's awesome. Estate Plan Stan, everybody, 363-7222. Is that right?
That's correct.
And estateplanstan.com. So easy to remember. Over in Pulaski, Tennessee, our great neighbors. And good to have you again.
And you know that if you turn around, you will see that phone number.
Yes.
And if you forget your own, you'll see your own phone number.
That's right. Got mine as well.
I'm somebody. I'm on the wall here.
Yes, you're on the wall up here. That's right.
Well, Jeff, it's always a pleasure, and I always look forward. I do enjoy doing this show on WDXE since you guys go into talk radio. So I hope the listeners enjoy it as much as I enjoy doing it. And I'll be back next Friday from 8 to 9 with the next episode of Bulletproof Estate Planning.
Thanks, buddy.
Thank you.